Omokudu, you are for which case?
I'm for Abiodu Ayonote.
Okay. Okay. Abiodun Ayonote. That is judgment number 2.
Yes, my lord.
Yes. So for now, we are doing Mr. Umar Diko Hassan. Counsel, Yusuf, IF Yusuf. IF Yusuf and Yakubu Philemon. And I saw one of them join.
My lord, I didn't get that.
Yakubu Philemon. Okay, good, good.
Yes, Lord.
Okay,
Yes.
it's your case now.
Yes, my name is Yakub Filimo, my lord.
Yes.
My humble appearance before the defendant. I appear for the defendant, my lord.
So what of claimant counsel?
He seems not to be in court, my lord.
Okay. Okay. The case is for judgment. Yakubu.
With utmost humility to your lordship.
No, I've entered your appearance. The case is what?
My humble appearance.
Yakubu Philemon.
Yeah. Yes, my lord.
The case is for what today?
The case is for judgment, my lord.
Okay. Are you ready?
We are ready to take the judgment, my lord, if my lord is ready, my lord.
Thank you.
As the court pleases, my lord.
The court is ready.
As the court pleases.
The judgment is ready. Okay. This is the judgment of the court. In the National Industrial Code of Nigeria, in the Akure Judicial Division, housing at Akure, before His Lordship Honorable Justice K.D. Damlak, dated the 28th day of September 2021, suit number NICM/IN/18/2019 between Mr. Umar Diko Hassan claimant and Federal High Court of Nigeria defendant. Judgment. The claimant commenced this suit by a complaint filed on the 15th October 2019. The complaint is accompanied by all the necessary documents and procedures required by the rules of court. The claimant seeks for the following relief. A. An order declaring the letter of dismissal dated 21st November 2018 issued by the defendant to the claimant null, void, and unconstitutional. Order declaring the letter of the claimant from service as null and void. An order directing the defendant to pay the claimant all outstanding salaries and allowances withheld during the pendency of the purported dismissal from November 2018 to any date the defendant pays the money. An order directing the defendant to pay the claimant the sum of 2.5 million naira and such further orders as the court may deem fit to make in the circumstance. The defendant filed a memorandum of appearance and statement of defense accompanied by all necessary processes by way of a motion on 6 February 2020. The claimant filed a reply without a witness statement on 23rd March 2020. Facts of the case. The claimant was employed by the Federal High Court on 13th November 2017 at the instance of Honorable Justice Nekizena L. Afolabi of the Ilorin Judicial Division, and he served as his lordship driver from 13th November 2017 until his lordship was transferred to Gombe Judicial Division of the court sometimes in 2018, but the claimant did not move to Gombe. The claimant claims he was not aware of the transfer of Honorable Justice Nekizena L. Afolabi and that he was not given a transfer letter. Neither was he aware of a circular to that effect. The claimant was dismissed for serious misconduct in accordance with the provisions of Rule 4815 of the FJSC Regulation 2010 according to the letter of dismissal, giving birth to the present suit. Case of the claimant testified. He adopted his witness statement on the 12th March 2021 while testifying as CW. The case of the claimant is that the defendant employed him as a motor driver mechanic by a letter dated 13 November 2017. He was posted to serve at Ilorin Judicial Division. He was unlawfully dismissed from service through a letter dated 21st November 2018. He was not given opportunity to be heard before his dismissal. He wrote a letter to the defendant through his counsel on 8 January 2019, and the defendant replied him on 12 March 2019. He has suffered serious hardship as a result of the purported dismissal, and he has not found any other job. Under cross-examination, the claimant testified as follows. I was working directly under Honorable Justice Nekizena L. Afolabi. I do not know if Honorable Justice Nekizena L. Afolabi was transferred to Gombe. Honorable Justice Nekizena L. Afolabi is no longer in Ilorin Division. I was not posted out of Ilorin. I never worked with any other judge in the Federal High Court. My appointment was probationary stroke temporary. Case of the defendant. By the statement of defense and the witness statement of DW, Imam Sarat Jumai, a senior registrar of the Federal High Court, Lorraine Judicial Division, dated 6 February 2020 and adopted on 12 March 2021. It is the case of the defendant that the claimant was lawfully dismissed from service, that the claimant who was employed at the instance of Honorable Justice L. Afolabi of the Lorraine Judicial Division of Federal High Court committed gross misconduct by refusing to go on posting from Ilorin to Gombe after being officially requested to do so through a circular reference number FHC 7219/1/22 at the request of the State Honorable Justice Nekizena L. Afolabi, the claimant being his driver, that the following steps were taken after the refusal of the claimant to proceed on transfer. And that is, Honorable Justice Nekizena L. Afolabi wrote a letter on 31st July 2018 to the Chief Registrar of the Federal High Court on the claimant's refusal to proceed on transfer. The litigation officer of Gombe Judicial Division wrote a letter on 22nd August 2018 to the Chief Registrar of the Federal High Court that the claimant did not report the division as per claimant's posting. Memo dated 14th September 2019 was written to the Chief Registrar of the Federal High Court requiring to the claimant's refusal to assume duty as a serious misconduct according to 481B of the FJSC 2010. Consequently, the defendant, through the Chief Registrar, issued a letter of dismissal from service dated 21st November 2018 to the claimant. The claimant contravened official directives of the defendant. Of examination, DW testified as follows. Exhibit ISJ 1 to 7 are not addressed to the claimant, except Exhibit ISJ 3. Exhibit ISJ 3 is addressed to the claimant by reason of its reference. Okay, by reason of his reference number, which is his file number and his name in the schedule. The letter was not copied to the claimant because his name is on the schedule. claimant's reply is that no disciplinary proceedings were ever conducted and he's not aware of the matter. He was not given posting letter, did not commit any gross misconduct. Final written address of defendant's counsel. The defense counsel formulated three issues. One, whether the action of the claimant before this honorable court is not statute barred. He argued that the matter was filed more than 3 months after the course of action. Two, whether from the circumstance of this case, the claimant ought to have known and in fact knew that he was to be posted to the Gombe Judicial Division of the defendant, and whether his refusal and failure to avail himself of the state reassignment amounts to gross misconduct and a violation of the Federal Judicial Service Commission Regulations 2010. He made submissions and concluded that he, in the circumstance, being the driver of Honorable Justice Afolabi, there is no way he could claim that he did not know that my lord was posted out of Ilorin to Gombe, and his refusal to go to Gombe was simply misconduct, gross misconduct. Then whether the procedure followed in dismissing the claimant from the service or defendant is valid and proper, having regard to the terms stipulated in claimant template of professional letter of employment, and whether the dismissal is in accordance with the provisions of the rules. Learned counsel submitted to answer the question in the positive. He cited some orders and rules of the cited Rule 59 of the FJSC rules, and submitted that the procedure adopted was proper. The final written address of claimant's counsel. Claimant counsel also listed three issues. The one is on the statute bar, and he concluded that this being an employment matter, that the statute of limitation, particularly Public Officers Protection Act, is not applicable to such matters. Then whether or not the dismissal of the claimant from the service by the defendant did not contravene the rule of fair hearing. It is submission of counsel that number one, the claimant was not issued any letter, that all the procedure adopted as earlier highlighted, the letter from my lord to the chief registrar, the letter from the SCR in Gombe, all through all those communications, including even the schedules, that none was served on the claimant, and none was addressed to the claimant, and none was served on the claimant, and only the suspension letter, the dismissal letter was served on the claimant, and therefore everything was done behind his back. He submitted that amounted to one of fair hearing. Then whether or not the claimant is entitled to his claim, he submitted that the claimant has proven his case and is entitled to his claims. Court decision. This is the main part. Now, I have read the pleadings, the evidence of the parties, the final written addresses of counsel, and studied the exhibit standard. I am of the opinion that the three similar issues formulated by both counsel can be married conveniently. I adopt them with minimal adjustments as follows. One, whether or not the action of the claimant is statute barred, considering the provision of Section 2A of the Public Officers Protection Act. Two, whether from the circumstance of this case, the claimant ought to have known and in fact knew that he was reposted to the Gombe Judicial Division of the defendant, and whether his refusal and failure to avail himself for the said transfer amounts to a gross misconduct and a violation of the FJSC Regulations 2010. Three, whether the procedure followed in dismissing the claimant from service of the defendant was in accordance with the provisions of the Federal Judicial Service Commission Regulation 2010 and did not contravene the rule of fair hearing. These issues shall now be considered seriatim. One, whether or not the action of the claimant is statute barred considering the provisions of Section 2A of the Public Officers Protection Act. It is not in doubt that the claimant was dismissed on 21st November 2018 and this suit was filed on 15th October 2019, far beyond 3 months. The claim of the claimant, however, is for wrongful dismissal and for unpaid salaries and severance allowance. There is no gainsaying the fact that the claim is based on a contract of service and one for work and labor done. The authorities are settled that the claim based on a contract of service and a claim for work and labor done are not covered by the provisions of the Public Officers Protection Act. See National Revenue Mobilization Allocation and Fiscal Commission and two others versus Ajibola Johnson and 10 others, 2019 2 Nigeria Weekly Law Report. Accordingly, this objection fails and is hereby dismissed. Issue 2. Whether from the circumstance of this case, the claimant ought to have known and in fact knew that he was reposted to the Gombe Judicial Division of the defendant, and whether his refusal and failure to avail himself for the said transfer amounts to a gross misconduct and a violation of the Federal Judicial Service Commission Regulations 2010. It is the case of the defendant that the claimant was employed at the instance of Honorable Justice Hezina I. Afolabi of the Federal High Court, and he served as driver to my lord. This was never denied. On the contrary, this is what the claimant affirmed under cross-examination. He said, I was working directly under Justice N.I. Afolabi. I do not know if Honorable Justice N.I. Afolabi was transferred to Gombe. I never worked with any other judge in the Federal High Court. Now, if the claimant was employed at the instance of Honorable Justice Nehizina I. Afolabi, was working directly under Justice N.I. Afolabi, and he never worked with any other judge in the Federal High Court, can he in good conscience and under any reasonable circumstance claim that he did not know and in the circumstance ought not to have known that Honorable Justice Afolabi was transferred to Gombe Judicial Division and thus himself so transferred? I answer in the negative. I hold that in the circumstance, the claimant ought not to have. The claimant ought to have known that Honorable, I hold that in the circumstance, the claimant ought to have known that Honorable Justice N.I. Afolabi was transferred to Gombe Judicial Division, and so was he. His contention in the opinion of the court is one in law simplicity as it is devoid of logic. It does not stand to reason for a driver who was working directly under a judge and who has never worked with any other judge to claim that he did not know that the said judge had been transferred to another division. The claimant is simply making a legal point that he was not formally issued a transfer letter. Whether his refusal and failure to avail himself for the said transfer amounts to a gross misconduct and a violation of the Federal Judicial Service Commission Regulation 2010 is now a legal question best suited for determination under Issue 3. Issue 3. Whether the procedure followed in dismissing the claimant from the service of the defendant was in accordance with the provisions of the Federal Judicial Service Commission Regulations 2010 and did not contravene the rule of fair hearing. Here it shall be imperative to consider this issue by recalling the case and arguments of the parties along with the exhibits tendered. The case of the claimant is that he was not given opportunity to be heard before his dismissal. Defendant contends that the claimant, who was employed at the instance of Honorable Justice Nehizena I. Afolabi of the Ilorin Judicial Division of the Federal High Court, committed gross misconduct by refusing to go from Ilorin to Gombe after being officially requested to do so through a circular number /7/1/22. The said information through a circular or any other means was denied by the claimant. According to the defendant, the following steps were taken after the refusal of the claimant to proceed on transfer. That is, Honorable Justice Nehizena I. of
What's up? I'm fine, sir. And yesterday, in fact, I'm sorry, sir. In fact, this morning I said I would call you. Yesterday night before I could sleep, I remember I don't call my number. Give me, sir.
Hello, sir.
Sorry, gentlemen, my network went bad. Had to change source of network. So I check again where the network went bad. According to the defendant, the following according to the defendant, the following steps were taken after the refusal of the claimant to proceed on transfer. Honorable Justice Mokizena I. Afolabi wrote a letter on 31st July 2018. Yes, Omokoro, you can, your mic. Honorable Justice Mokizena I. Afolabi wrote a letter on 31st July 2018 to the Chief Registrar of the Federal High Court on the claimant's refusal to transfer. The litigation officer of Gombe Judicial Division wrote a letter on 22nd August 2018 to the Chief Registrar of the Federal High Court that the claimant was not report to the Judicial Division as per claimant's posting. A memo dated 14th September 2018 was written to the Chief Registrar of the Federal High Court referring to the claimant's assumed duty as a serious misconduct according to report Z1B of the FJ 2010. Consequently, defendants, through the chief registrar, issued a letter of dismissal from service dated 21st November 2018 to the claimant. However, this is what W testified under cross-examination. Exhibit ISJ 1 to 7, those are the documents referred to, the processes that the defendant said they took. Those are the exhibits tendered as exhibit ISJ 1 to 7. That the exhibits ISJ 1 to 7 are not addressed to the claimant except exhibit ISJ 3. Exhibit ISJ 3 is addressed to the claimant by reason of his reference number, which is his file number and his name on the schedule. The letter was not copied to the claimant because his name is on the schedule. Exhibit ISJ 3 is the circular schedule, stroke schedule or memo dated 26 July 2018, making reference to the said transfer of the claimant. The case of the claimant as per his claim and evidence is captured clearly by his counsel in the final written address as follows. That the claimant was not aware of any posting that he was served and all the documents relied upon by claimants are correspondence among the chief registrar, senior registrar, principal executive officer, principal admin office, and His Lordship, Honorable Justice N.I. Apolabi, that none of the documents shows that claimant was served or given any posting letter or memo of 26 July 2018, and no indication that he received same. Now, there is no evidence that any of the above documents was served on the claimant. The said circular reference number FAC/7219/1/22 was neither addressed to nor served on the claimant. That fact was neither pleaded by the defendant. The circular shows on the face of it that it was issued by the chief registrar of the defendant at Abuja and copied to 10 persons, including the senior registrar Ilorin, whose copy was tendered in court. It was not copied to the claimant. There is neither pleading nor evidence that the senior registrar Ilorin served the claimant a copy of the said circular. The claimant can only be said to have refused to go on posting from Ilorin to Gombe after being officially requested to do so through a circular reference number FSC 7219/1/22 when the said circular is shown to have been served on him. In this case, it has not been so shown. I have studied all the documents and correspondences above referred. I agree with claimant's counsel submission that make it an I agree with claimant's counsel submission and make it my findings that the claimant was not legally aware of any posting, that he was not served with any letter or circular of posting. All the documents relied upon by the claimant, uh, all documents relied upon by the defendant are correspondence among chief registrar, senior registrar, principal executive, principal admin officer, and his lordship, Honorable Justice N.I. Apolabi, and none of the documents shows that the claimant was served, and no indication that he received them, nor is there any pleading or evidence to that effect. If fair hearing was required in this case, the claimant was offered none. The learned counsel for the defendant brilliantly argued that a wider reading of the rules also revealed that Rule 59.1 also made provisions for procedure to be followed in dismissing an officer, especially for the kind of misconduct with which the claimant was charged with. Hence, the claimant was dismissed in accordance with Rule 59.1 of the FJSC Regulation 2010 as evidence as evidenced in Exhibit UDH4. The said Rule 59.1 does not provide for any query or panel of inquiry to be set up before an officer can be dismissed, that the rule provided an alternative to the procedure stipulated in Rule 61 of FJSC 2010. Now, Rule 59.1 provides as follows, and I quote, without prejudice to the power to institute disciplinary proceedings in respect of any absence from duty without leave or reasonable cause, where an officer is absent from duty without leave or reasonable cause, the commission dismiss him without following the procedure prescribed in Regulation 61 of these regulations. This rule is strictly applicable to absence from duty without leave or reasonable cause. By Exhibit UDH2, the dismissal letter, the claimant was not dismissed for absence from duty without leave or reasonable cause under Regulation 59.1, but for willful act or omission or general misconduct as to scandalize the public and disobedience of lawful order, such as refusal to proceed on transfer or to accept posting, etc., under Rule 48(1)(b). Although the two provisions could be applicable in one and the same circumstance, one will not be necessarily applicable when only the other is specifically stated in the letter of dismissal. The argument of learned counsel therefore amounts to making a new case for the defendant in his final written address. Accordingly, same is hereby discountenanced. It is important to state here that the claimant was employed on 13th November 2017 on probation. He was dismissed on 21st November 2018 after serving for a period of 1 year, 8 days. But the probationary period was not stated in his employment letter. However, paragraph 2 of the appointment letter reads, this appointment is subject to all conditions of service applicable to probationary, subpensionable, temporary staff in the Federal Civil Service. Section 3, Rule 020301 of the Federal Service Rules stipulates that officers on probation will be required to serve for 2 years before being confirmed in the service. Accordingly, at the time of his dismissal, the claimant was still a probationary staff. The allegation of disobedience of lawful orders, such as refusal to proceed on transfer or to accept posting for which the claimant was dismissed, is indeed an act of gross misconduct for which the defendant is in law entitled to dismiss the claimant summarily, provided the claimant is afforded fair hearing. See the case of Mr. Syed Kamar Ahmed versus Ahmadu Bello University, ABU, and another, LPA 2016, LPAR 40261, where the court held an act of gross misconduct has been defined as a conduct that is of grave and weighty character as to undermine the confidence which should exist between the employee and the employer. Working against the deep interest of the employer amounts to gross misconduct, which would entitle the employer to summarily dismiss the employee. Cited Nwobosi. Then, in exercising this power, the law no longer draws any distinction between an ordinary master servant employment and an employment certificate level with respect to the right of the employer to summarily dismiss an employee for acts of gross misconduct, Yusuf and UBN Limited. It is now settled that an employer can summarily and without any much ado dismiss an employee in all cases of gross misconduct, provided that the affected employee is given a fair hearing, whether the affected employee is in private employment or statutory employment. Zenith ZD versus River State Civil Service Commission and Francis Arinze versus FBN cited. In Mr. Benjamin Billy versus Multilink Telecommunication Limited 2017, LPALR 41862CA, the court held Panimpar JCA that it is right that an employer has the unfettered right to dismiss an employee for gross misconduct in accordance with the condition of service in Wobosin and ACB Limited, where the court held us, an employer has a common law right to dismiss any employee without notice on the ground that the employees, on the ground of the employee's gross misconduct. The caveat there is that the employee be given fair hearing. See Mr. Syed Kamar Ahmed versus Ahmadu Bello University, ABU. From the above authorities, it is clear that if the claimant committed gross misconduct, he was entitled to fair hearing before dismissal, and he was not accorded fair hearing. Now, the claimant was a probationary staff. The position of the law is that the employer can dismiss or terminate the employment at any time before the expiration of the probationary period, but in accordance with the express or implied terms of the contract, and it is not necessary for the employer to prove the reasons stated in the notice. Simeon or University of Jos where the court held
Outro
the essence
gaguinho
of a probationary appointment is that the employer retains the right not to confirm the appointment until after a specified period. Where the contract of employment provides that the appointment is subject to a probationary period of a certain length of time, this does not give the employee a legal right to be employed for that length of time, and the employer may lawfully dismiss him before the expiry of that period. Where there is a notice of dismissal or termination of appointment of an employee by the employer, it's necessary for the employer to prove the notice. The only obligation on him is to show that the contract was terminated in accordance with the express or implied terms of the contract, regardless of whether the appointment is on permanent or probationary or temporary basis. In Albishak versus National Productivity Center and another 2015 FPLR, the court held that it is right that an officer on probation does not enjoy the same condition of service with an officer whose appointment has been confirmed. His status in the establishment is more or less temporary during the period of probation. Hence, the process of his removal is not subject to strict adherence to rules as is the case with a confirmed officer. That is why the rules or even Exhibit P1 provided for 1 month notice of termination of the appointment on both sides. Thus is the case of Ipilo and CBN. It was held, thus in the case of Idigbe CBN 2009, I have the report part 672, page 302, it was held that in the termination of the appointment of an officer on probation, no procedure needs to be followed provided there is satisfaction that there is a good cause for termination. But in the termination of a confirmed officer, the procedure for termination must be followed, otherwise the termination is invalid. See also Al-Hassan versus ABU Zaria. In Zuku versus University of Jos, where the Supreme Court held that once the condition laid down for the termination of appointment during the probationary period is satisfied or complied with, an employee cannot justifiably complain. See also Al-Hajj Baba versus Nigerian Civil Aviation Transport Center, United PLC versus APA, and Simeon versus College of Education, Ekiadolo, Benin, citation fully supplied. Having failed to afford the claimant fair hearing, even though he was a probationary staff, the dismissal falls short of the requirement of the law. However, having found that in the circumstance the claimant ought to have known that Honorable Justice N.R. Folobi was transferred to Gombe Judicial Division, and so was he. The effect of the failure to afford the claimant, a probationary staff, fair hearing is that the said dismissal is hereby committed to termination. The requirement of the law is that the termination shall be in line with the terms of the contract. Paragraph 3 of the letter of appointment provides as follows. I am also to inform you, among other things, A, that unless you are dismissed, the government may at any time terminate your appointment or engagement by a month's notice in writing or with the consent in writing of your head of department by the payment of a month's salary in lieu of notice. Having remitted the claimant's dismissal to termination, I hold that the claimant is entitled to 1 month's salary in lieu of notice, calculated on the basis of an annual salary of 242,994, 242,994 naira, and the defendant is hereby ordered to pay same to the claimant. The claimant has prayed for payment of salaries and allowances withheld during the period of the purported dismissal. Being a staff on probation who is not asking for reinstatement but severance allowance, the claimant is not entitled to salaries from the time of his dismissal, now remitted to termination. but only 1 month salary in lieu of notice, which has already been awarded. This claim fails. The claimant has also asked for severance allowance of 2,500,000 naira. The claimant has not proven that he is entitled to severance allowance after 1 year of service. He has not proven how he arrived at the sum of 2,500,000 naira. This claim also fails for want of proof. On the whole, and for the avoidance of doubt, the case of the claimant succeeds in part and is hereby declared and ordered as follows. 1. The dismissal of the claimant was done in violation to his right to fair hearing. The said dismissal is hereby remitted to termination. The claimant is entitled to 1 month salary in lieu of notice, and the defendant is hereby ordered to pay the claimant 1 month salary in lieu of notice, calculated on the basis of an annual salary of 242,994 naira. I make no order as to cost. This is the judgment of the court, and it is entered accordingly.
As the court pleases.
Yakubu.
Yes, my lord.
As the court pleases.
My lord,
I'm sorry, my lord, sir.
Okay.
I'm sorry, my lord.
Yes.
Sorry, the network give us disappointment. That's why we did join on time. My lord,
Who is this Lawan?
humility. My name is IF. I appear with SI Abdulkadir.
You are IF Yusuf.
Yes, my lord, sir.
Okay, IF Yusuf with.
Yes, I appear with SI Abdulkadir.
With SI Abdul Kadir for the claimant.
Yes, my lord.
What's your comment? I've just delivered the judgment.
My lord, I really appreciate the industry Lord put in me in this judgment, sir. We are so much grateful, sir. Thank you, sir.
Yes.
Yes, my lord, on behalf of the defendant, my lord, we first of all appreciate my lord for not only delivering judgment in accordance with the law, but also reminding us of the rights of our employees to constitutional fair hearing. My lord, we appreciate my lord's industry, and we pray for more wisdom and strength to carry on this assignment. We are most grateful, my lord.
Thank you.
Let's call pleases.
So copies of the judgment will be ready for collection even today.
As the court pleases. Thank you, my lord. Thank you, my lord.
Thank you very much. You're welcome.
Yes, my lord. May I respectfully seek my lord's indulgence to visit? Yes, my lord.
Yeah, you can. You can.
Okay, as the court pleases. Thank you, my lord.
Thank you, sir. Thank you, my lord, sir.
Yes. Comrade Abiodun Ayanote. Yes, yes, Omokudu, yes. I think you are for this case. Appearance, please, Comrade Abiodun Ayanote and Comrade Tony Osebobor versus Chief Odion Olaiye, Suleiman Musa Felix, Ailoge, Mahmoud Aronoke, National Union of Road Transport Workers, Edo State Chapter, and the National Union of Road Transport Workers. Appearance, please. Appearance. Unmute your mic. Accommodate, unmute your mic and talk. Good. Please talk. now. Appearance. Okay. Claimant. Anybody for the defendant?
My Lord,
Yes.
I am Elder Chief NP Osifo.
Okay.
With me, my Lord, is my
Elder.
learned friend. With me, my Lord.
Wait, let me finish recording you. Let me finish recording you. Elder
Okay.
Chief NP Osifo with, yes, you are with
Elder Chief NP Osifo, my Lord.
yes,
Appearing with me, my learned friend.
yes.
Miss Osayi Osifo.
Miss Osayi.
Osayi Osifo. My Lord,
Okay.
my,
Is that
my,
your
my
daughter?
last daughter.
Yes. From the name. That's a big pride for you.
My Lord,
and we thank you for giving us.
Thank you, my Lord.
We thank you for giving the bar a lawyer that will replace you when you are gone. You are for the defendants. Okay, the case is for judgment. And the judgment is ready. And this is the judgment of the court in the National Industrial Court of Nigeria in the Judicial Division, holding at Akure before His Lordship Honorable Justice K.D. Damlak, dated 28th day of September 2021, suit number NIS/AK/17/2020 between Abiodun, is it Abiodun or Abiodun? Abiodun Ayanote, Comrade Tony Osemobo, and Chief Ojon Olaye, Suleiman Musa, Felix Ailoge, Mahmoud Aronokale, National Union of Road Transport Workers, Edo State Chapter, National Union of Road Transport Workers, NURTW. Judgment. The claimants took out an originating summons on 29 June 2020, seeking the determination of 4 questions and the grant of 5 reliefs as follows. 1.
Sorry, my Lord.
Whether in view of the in NICS/BEN/12/2017 between Comrade Saturday, Mohammed, 3 others versus Chief Ojon Olaye and 2 others, the first defendant can validly continue to function as the chairman, National Union of Road Transport Workers, Edo State Chapter. 2. Whether in view of the provision and effect of Article 4(2) sub-4 VII and VIII of the Constitution of the National Union of Road Transport Workers, the first defendant can continue to act as the state chairman of National Union of Road Transport Workers, Edo State Chapter, having exhausted his 2 tenure between 2004 to 2012. 3. Whether the first defendant can lawfully participate as the head of the state executive council to take lawful decisions in view of the judgment in suit number NICS/BEN/12/2017 to 42 for VII and Article 17(1) of the Constitution of the National Union of Road Transport Workers. 4. Whether the second and third defendants can suspend any member, executive member, or officers of National Union of road transport workers in view of Article 23(7) and Article 27(4) of the Constitution of the National Union of Road Transport Workers, that if the answer to all or any of the above issues is in the negative, the court is therefore prayed to make the following A. A declaration that the first defendant continues stay in office as the chairman, National Union of Road Transport Workers, Edo State Chapter, having exhausted his 2 term is illegal, null and void. B. A declaration that the letter of suspension issued by the second and third defendants and the withdrawal of appointment of the claimants is ultra virus the powers of the second and third defendants and therefore illegal, null and void. C. A declaration that the appointment of the fourth defendant as the Edo State Heavy and Light Truck Coordinator of the National Union of Road Transport Workers State Chapter by the second and third defendants is ultra virus their powers, therefore illegal, null and void. An order mandating the sixth defendant to conduct elections into various offices of the fifth defendant on a date to be fixed by this honorable court from June 2020 in line with the Constitution of the National Union of Road Transport Workers. E. An order of perpetual injunction restraining the first to third defendants for themselves, their servants, agents, privileges, and whosoever caught from further interfering with the activities and status of the claimants as members and officers of the National Union of Road Transport Workers State Chapter. The defendants filed a memorandum of appearance and a counter affidavit on 13th January 2021, and the claimants filed a affidavit on 12th February 2021. Please, Osifo, you are still talking while I'm delivering judgment.
I'm sorry, my lord. I'm sorry, sir.
You have to mute your mic. You can mute your mic, then you can talk. You understand? But
Yes,
not while your mic is on. Thank you. Because it's not only us that are listening. Even if it's only us, you know it's not proper.
Yes, my lord.
In a 26-paragraph affidavit in support of the originating summons, the first claimant deposed on oath that he is an elected executive member of the National Union of Road Transport Workers, Edo State Chapter. Generally, that the first defendant refused to relinquish power and that in the suit number NICN/BN/12/2017 Exhibit A, the court declared that the man has already spent his 2 tenures of 4 years each, and that he knows that by 2nd day of June 2020, the elections will be due to be conducted into offices of the fifth defendant. That because both myself and the first claimant are interested as aspirants into various offices of the union and to further perpetuate himself in office, the first defendant is using the instrumentality of second and third defendant to issue myself and the first claimant suspension and withdrawal of appointment letters. The second defendant without authority has issued an offer of appointment to the fourth defendant to replace my position as the Edo State Heavy and Light Truck Coordinator. That we have exhausted all the internal mechanisms for the settlement of the tenure of the first defendant who has not yielded any result. In his written address, Learned Afaleokai, Esquire of Counsel for the claimants, submitted at Exhibit A and B the Constitution of the Union and the judgment of this court in NICN/BN/12/2017 provide the answer to questions 1 and 2. Counsel cited pages 2 of the judgment. Page 2 of the judgment. On the third issue, Learned Counsel submitted that first defendant, having exhausted his tenure in 2012, as interpreted in Exhibit B, cannot validly participate and take a valid decision as a member and of the state, as a member of the State Executive Council, that if first defendant is illegally acting as the state chairman, his tenure having expired, it therefore means that any decision so arrived at by the state executive council presided over by the first defendant is a nullity, as anything placed on nothing cannot stand. That the second and third defendants, acting state secretary and HOD mass transit heavy truck cannot validly suspend the claimant or any officer of the fifth and sixth defendant. The function of the second and third defendants are provided in Article 23(7) and Article 27(4) of the Constitution of Nigeria Union Road Transport Workers does not include suspension and appointment of officers. Counter affidavit of the defendants. In a 20-paragraph counter affidavit deposed to by the first defendant, he deposed that upon being dissatisfied with the judgment in NICN/BN/12/2017, the first defendant in this case filed an appeal against the state judgment in suit number. It should be appeal number, not suit number anymore. At the Court of Appeal, it is no longer suit number, but appeal number. Please take note. In suit number CA/AK/128/18. The first defendant has done only one tenure as there was no activity between 2012 and 2017, and first defendant did not contest for a second tenure, as the Edo state government did not allow the union operate between 2012 and 2017. The originating summons is not suitable for the matter like this one in which facts are hostile, that is, where the facts are opposed to each other. The first defendant has not done 2 terms, but is currently doing the second tenure after he contested and won when activities resumed. That the issue whether the first defendant has done his second tenure or not will require oral evidence and is not a matter that can be decided on originating summons. The national body of the fifth defender invited the first and second claimants to appear before the disciplinary committee. When they failed to appear, the disciplinary committee issued its report. The national body withdrew the appointment of the second claimant via a letter attached here with Exhibit D5. The national body in March 2020 gave approval to the suspension of the first and second claimants. The fifth defendant, for reasons stated above, suspended the first and second claimants via letters of suspension attached as Exhibit D7 and D8. Further and better affidavit of the claimants, it is deposed that the facts in the original summons not disclose any conflict that warrants oral evidence being called. That learned counsel submit that there are no facts deposed to by the defendants that challenge the documents attached to the originating summons that warrants oral evidence being called to clarify the conflicts, particularly when this court is called upon to look at the contents of the documents attached and interpret them in line with the relief sought by the claimants. Additional written address of parties on question raised by the court. When counsels adopted the originating summons and counter affidavit on 27th April 2021, the court adjourned to 24th May 2021 for judgment. While studying the case, the court saw the need for addresses of counsel on local standard of the claimants in view of the purported suspension of the claimants, which is an issue to be determined. Accordingly, the court called back counsels on 28 June 2021 and asked them to address the court on the question. I quote, does a suspended member of an association have the local standard to sue to enforce the provisions of the association's constitution, quotation close? Both counsels submitted their written addresses on the issue and adopted them on 28 July 2021. Claimant's additional written address. Learned Claimants Council identified the question as being distilled from question 4 and relief B of the originating summons on the basis of Exhibit E attached to the originating summons. He further argued that it is clear that the claimants applicants are challenging their method of suspension alongside other reliefs vis-a-vis the power of the secretary to suspend a state officer of the union in view of Article 27 for National Union of Road Transport Workers. It is the submission of council that it is clear that the secretary was not acting under any instruction as clearly shown in the letter of suspension. He cited Kathleen Olaife versus University of Ibadan. It is the further submission of counsel that there is nothing preventing the court from determining the status of the second and third defendant for the issuance of letters of suspension on the claimants, that the only body vested with the power to discipline state officers is the State Executive Council in line with the procedure outlined in Article 42 of the Union Constitution, which is not on this case. Council conversed that the decision to suspend any executive member of the union is taken by the State Executive Council duly constituted, who also issue letter of suspension. He relied on Article 71 of the union's constitution. The argument of the claimant is that they were challenging that before they were allegedly suspended by the secretary. The tenure of office of the state chairman has long expired and therefore cannot validly constitute a state council to take any valid decision, and that more so, the decision leading to the purported suspension was taken on a matter revolving around the state chairman whose tenure of office has long expired. He concluded that a suspended member of the union who alleges that he was unlawfully suspended has the local standard to challenge the method of suspension and call for the interpretation of the union's constitution by the court. Therefore, the claimants have the local standard to institute this defendant's additional written address. It is the contention of the defense counsel that by Article 42 8I2 I and II of the union's constitution, the claimants applicants have the right to appeal, for which they have failed to exercise as such. By Article 42(6)(I), the claimants do not have the normal rights and privileges of the officer or member of the association during the period of the suspension. On the locus of the claimants to enforce the provisions of this association, relying on the authority of Adeneye and Efogwa, the claimants have not shown what right or obligation they have that has been, is bound to be, or is in any immediate danger of being violated. Refer to cases there. Council submitted that what confers on a party the right to seek to enforce provisions of the Constitution of the Union is the membership of such a party as a member of the Union. And it is that membership that he is able to show that he has immediate interest, which is at risk, or a future interest. In the instant case, the claimants cannot show they have an interest above that of every other person, hence lacks local standard. And the membership of the union is what confers on them local standard, and that the claimants are not proper parties in this case. Cited cases, their counsel submitted that the claimants do not have the right to secure the court's audience on an issue of a constitution of a body they no longer have rights or privileges in. Hence, the claimants, being non-members, do not have local standard to sue the union, nor inquire into the activities of the union court's decision. Before delving into the merits of this case, it is pertinent to determine some preliminary issues. One is the argument of claimant counsel that the counter affidavit of the defendants is incompetent for want of a written address and so should be discountenanced. The second is the contention of the defendants that the facts of this case are hostile and so not suitable for originating summons. On the objection of the claimant, it is true that the defendant did not file a written address in support of the counter affidavit. The defense counsel, while adopting his counter affidavit, responded by submitting that once the counter affidavit have been properly filed, the court shall look at it and determine the case using the said counter affidavit. It is pertinent to observe that this case was argued on 27th April 2021 when both counsels said they were ready, particularly Afalio Kai, Esquire of Counsel for the claimant said, our originating summons is ripe for hearing and we are ready. Osifo Esquire of Counsel for the defendant said, we are very ready. The issue of the absence of a written address of defendant's counsel was raised and responded to. The case was adjourned to 24th May 2021 for judgment. On 20th May 2021, Lanet P.E. Norma Esquire of NP Osifo and Co. filed a process titled Additional Submissions in the registry of this court. This process is, to say the least, strange. It is coming 23 days after adoption of the originating summons and counter affidavit. There is no room for such a process in the rules of this court. To use this process will be to deny the claimant fair hearing. There is not even a motion for any order whatsoever in respect of the said process. Counsel just filed it as of right. Even when judgment could not be written and parties were called upon on 28th June 2021 and asked to file additional written addresses, which was adopted on 28th July 2021. Learned counsel did not at least try to seek leave of court in respect of the said additional submission. So it can be contested by the other party. Neither was the said additional submission adopted. It is also to be observed that the title additional submission is misleading in that it presupposes that the defendants had an initial written submission and this is an additional, but the defendants did not accompany their counter affidavit which was adopted with any written submission. Long and short, the additional submissions filed on 20th May 2021 by the defendants' counsel is hereby discountenanced. The question now is whether the court should close its eyes to the defendant's adopted counter affidavit for want of written address or use the said counter affidavit. For a start, Order 15, Rule 5 of the rules of this court provides as follows. Where a party served with an originating summons with any other accompanying documents and or any recording by an electronic device as stipulated in Order 3, Rule 16 of these rules intends to contest the originating summons. Such party shall not later than 14 days thereafter or any other time prescribed file a counter affidavit thereto, which shall be accompanied by A, other relevant documents, if any, B, a written address in opposition to the argument advanced by the applicant, or C, any records of data relevant to parties' defense in an electronic storage. It is to be observed that a written address is argument and not evidence. A written address is simply meant to be an argument in support of the originating summons or in opposition to the argument advanced by the opponent. C. Abdul Qadir Aliu and others versus Intercontinental Bank PLC and another, where the court held it is settled law that the arguments of the arguments in the written address of counsel do not constitute evidence upon which a court can act. More so, even if it is taken that there is no counter affidavit, the case would still be decided on its merits. The winning points will not be awarded to the party present as in a football match. See HDP versus INEC citation supplied, where the Apex Court held it is indeed true that the petitioner filed a response, that is written address, to the third respondent's motion. Sorry, I take it again. It is indeed true that the petitioner filed no response, i.e. written address, to the third respondent's motion. This, however, does not ipso facto imply that the objections raised in the third respondent's motion must be sustained without more. It is still for the court to consider the merit and the merit of the objections for the purpose of sustaining or overruling them. The evidence before the court in our original summons are the affidavit and counter affidavits and their attached documents. It does not accord with logic and justice to disregard evidence for absence of argument of counsel. The situation would be different if it were a complaint and the statement of defense has no written witness statement on oath, as it would amount to pleading without evidence. In the circumstance of this case, using the counter affidavit of the defendant will in no way prejudice the claimant or cause any injustice. The evidence of the defendants on oath will accordingly be used. This objection fails. The second preliminary issue is the contention of the defendants that the facts of this case are contentious, so not suitable for originating summons. It is the case of the claimants in paragraph 6 and 7 of the affidavit in support of the originating summons that the first defendant spent 2 tenures in 2012. This is the deposition of the defendant, paragraph 5 to 8 of the counter affidavit. The first defendant has done only 1 tenure as there was no activity between 2012 and 2017. And first defendant did not contest for a second tenure as the Edo State government did not allow the union operate between 2012 and 2017. It was only after the Edo State government lifted the ban that the union started to operate. Originating summons is not suitable for a matter like this one in which facts are hostile, that is, where the facts are opposed to each other. The first defendant has not done 2 tenure, but is currently doing the second tenure after he contested and won when activities resumed. The issue of whether the first defendant has done his second tenure or not will require oral evidence and is not a matter that can be decided by originating summons. Issue of whether the union was active between 2012 and 2016 or for how long the activities of the union was grounded is a matter that will require evidence and is not a matter that can be settled by originating summons. Now the court talks. Whether or not the first defendant has spent 2 tenures in 2012 is what this court, per Oyewumi J, decided in NICN/BEN/12/2012. In that case, the claimants avert that the first defendant, having spent 2 tenures of 4 years each, that is between 2004 to 2012, as the chairman of National Union of Road Transport Workers, Edo State, is not eligible to contest again, considering the fact that he has spent the maximum period of 8 years. The first defendant in the present suit was also first defendant in NICN/BN/12/2017. The case was filed on 10 July 2017. and the judgment of the court was on 13 March 2018. My Lord Oyewumi J. held in the second paragraph at page 8 of the judgment thus: claimants are seeking a declaration that the first defendant has served the constitutional 8 years tenure of 4 years each by Article 42, Section 4 VII. I have found earlier that the first defendant have indeed served his 2 terms of 4 years each, and thus his action by staying over as chairman of the second defendant, Edo State, is ultra virus, and whoever gave him the certificate of return dated 2nd June 2016 acted ultra virus. The claimants are accordingly relying on this court's decision in canvassing that the first defendant has already spent 2 tenures of 4 years each. The fact that the defendants are contesting it is immaterial before this court until that finding is set aside by the Court of Appeal. The claimant also deposed in paragraph 14 of the affidavit in support of the originating summons that I know as a fact that by 2nd day of June 2020, the election will be due to be conducted into the offices of the fifth defendant. The defendants did not deny this in any paragraph of the counter affidavit. I accordingly find that there are no hostile facts in this case to warrant a transfer to the general court list. This objection also fails. Merit of the case. It is to be observed that there are 4 questions for determination and 5 reliefs sought. Questions 1, 2, and 3 relate to the validity of the first defendant continuing in office as chairman of NURTW Edo State Chapter in view of the judgment of this court in NICN/BEN/12/2017 and Article 17(1) and 20 and 42(4) of the Constitution of the NURTW, and reliefs A and D are anchored on the determination of these questions. Similarly, question 4 deals with the power of the second and third defendants to suspend any member, executive, or officer of the NURTW in view of the provisions of Article 23(7) and 27(4) of the Constitution of the NURTW, and reliefs B, C, and E are anchored on this question. The court shall determine this case by looking at the relief sought, bearing in mind the relevant questions for determination and the judgment of this court in NICN/BEN/12/2017, as well as the provisions of the Constitution of the NURTW. In the circumstance of this case, where the suspension of the claimants have been put in issue, it is right to determine question 4 first. As earlier pointed out, reliefs B, C, and E are grantable if question 4 is determined in favor of the claimants. The question is whether the second and third defendants can suspend the claimants or withdraw the appointment of the claimants in the union in view of the provisions of Article 23(7) and 27(4) of the Constitution of the NURTW. The defense, according to paragraphs 11 to 14 of the counter affidavit, is, and I quote, the national body of the fifth defendant invited the first and second claimants to appear before the disciplinary committee. When they failed to appear, the disciplinary committee issued its report. The national body withdrew the appointment of the second claimant via a letter attached herewith as Exhibit D5. The national body in March 2020 gave approval to the suspension of the first and second claimants. The fifth defendant, for reasons stated above, suspended the first and second claimants via letters of suspension attached as Exhibit D7 and D8. Why is this thing making that noise? Okay. The deposition in paragraph 4 of the claimants for the affidavit that the facts deposited in paragraphs 2 to 19, which of course covers 11 to 14, isn't it, of the defendant's counter affidavit are not true, is not sufficient denial of these facts, and so the depositions in paragraphs 11 to 14 of the counter affidavit are taken as true, particularly given the contents of Exhibits D3 to D9. The said Article 23(7) provides for the functions of the Department of Mass Transit and Heavy Light Trucks, and Article 27(4) of the Constitution of the Union provides for the office and functions of the State Secretary, who is to be appointed by the National Executive Council. The question whether the second and third defendants can suspend or withdraw the appointment of the claimants is on the assumption that the second and third defendants suspended or withdrew the appointment of the claimants. The claimants did not, in paragraph 15 and 16 of the affidavit, where the second and third defendants are mentioned, tell the court what position the second and third defendants hold at the national or Edo State chapter of NURTW. However, on claimants exhibits E and F, particularly the two letters of suspension of the two claimants, exhibit E, dated 9th March 2020 on page 2, second and third paragraph read, based on the recommendation of the disciplinary committee, based on the recommendation of the disciplinary committee, the State Council now write to inform the national headquarters, Abuja, about the matter, and on 6th of March 2020, the national headquarters, Abuja, approved the suspension. I am now informing you that you, Tonu Osemobo, and Abiodun Oyonote is hereby suspended from the National Union of Road Transport Workers, Edo State, with effect from 9th March 2020. The last sentence on paragraph 5 at page 2 reads as follows. A letter approving their suspension from National Headquarters, Abuja, is hereby attached for your perusal. The suspension letters were signed by Felix Ailoge, State Secretary, third defendant. If he is the State Secretary, by the contents of the letter, he was not the one suspending the claimants, but he was informing them of the decisions of the National Headquarters and Edo State Chapter of the Union as the claimant's branch secretary. The suspension was not his act, and he did not claim to do so in the letters. He acted in an official capacity, not in a personal capacity. Exhibit F, letters of withdrawal of appointment of second claimant and letter of approval of appointment of fourth defendant as Edo State Heavy and Light Trucks Coordinator, dated 20th March 2020, from the National Headquarters. It was signed by Brother Suleiman S. Musa, HOD Mass Transit Truck, Heavy Trucks, the second defendant. Once again, the letter conveys the second claimant and the fourth defendant the approval of the National Secretariat. It is not the act of the second defendant. The claimants claim in paragraph 16 of their affidavit that the second defendant acted without authority. His authority is as contained in the letters. The claimants have not proven the contrary. Supposing that the claimants should be understood as challenging the action of the fifth and sixth defendants to suspend them and withdraw their appointments, the claimants have not in any way shown how and why the action was wrong, and it will not be the duty of the court as an arbiter to provide any such answer. The claimant have not told the court how the process of appointment or removal of state and light truck coordinator is supposed to be done, by who, and pursuant to which section of the Sixth Defendants Constitution. The claimants do not rely on any provision of the Union's Constitution relating to appointment and removal of state heavy and light trucks coordinator. The implication of the above findings is that question 4 is resolved against the claimants. The second and third defendants acted for the National Secretariat, and their lack of authority has not been proven. The claimants were properly suspended and removed from office. The unlawfulness of the suspension and removal has not been proven. Accordingly, prayers B and C fail and are refused. The claimant remains suspended, and the second claimant remains removed from his appointment as Edo State Heavy and Light Trust Coordinator. Turning to questions 1, 2, and 3. These questions centers on the attempt of the claimants to enforce the provisions of the association's constitution. Having determined that the claimants were properly suspended, the question now is whether the claimants who are adjudged to have been properly suspended have the local standard to sue to enforce the provisions of the association's constitution by compelling the fifth and sixth defendants to conduct elections into offices of the fifth defendant, and the claimant sue to enforce the provisions of the constitution besides challenging their suspension and removal. It is imperative to point out that the written address of the claimant counsel on the question raised by the court does not demonstrate a clear understanding of the question, as counsel seems to simply take it as a liberty to argue his case. The question raised by the court is, does a suspended member of an association have the local standard to sue to enforce the provisions of the association's constitution? This must be understood as only coming into play in the event that the court finds that the claimants were lawfully suspended. The right of the claimants to challenge their suspension was not contemplated under this question. The defense counsel properly understood this and properly addressed the question. The defense counsel argument is as follows. The claimants do not have the normal rights and privileges of the officer or member of the association during the period of the suspension. The claimants have no real stake or interest in the provisions of the association's constitution they now seek to enforce. What confers on a party the right to seek to enforce the provisions of the constitution of the union is the membership of such a party as a member of the union. This is a clear understanding of the question put by the court. Now, the claimants become suspended members of the fifth defendant from 9th March 2020. This suit was filed on 29 June 2020. There is no averment or evidence that the said suspension has been lifted. Do the claimants still have the right to enforce the Constitution by compelling the fifth and sixth defendants to conduct elections into offices of the fifth defendant, having failed to successfully challenge their suspension? The word suspension was defined in National Judicial Council and others versus Honorable Justice Jibril Babajide Alade Jana and others, 2014 LPLR by the Court of Appeal Earth, and it also quoted another case. It says, in the case of University of Calabar versus Esaga, 1999, Phone Against Report 502, 793, it was held that suspension means a temporary privation or deprivation, cessation or stoppage of or from the privileges and rights of a person. Suspension means to defer, lay aside, or hold in abeyance. See also Longe and First Bank Nigeria PLC citation supplied, the Saga University of Calabar citation supplied, Akin and Ju versus Unilorin citation supplied, Damisa and UBA citation supplied. I find the submission of the Learned Defenders Council to be on firm ground by the suspension of the claimants on 9th March 2020, which suspension is not shown to have been lifted yet. The rights and privileges of the claimants as members have been temporarily deprived, seized, deferred, laid aside, stopped, or put in abeyance until the suspension is lifted. This means the claimants cannot, during the pendency of their suspension, exercise the rights and privileges of a member, such as to compel the union to conduct elections. Accordingly, this court hereby declines the determination of questions 1 and 2 and 1, 2, and 3, and relieves A and D for want of local standard on the part of the claimants and thus want of jurisdiction on the part of the court. parties are to bear their respective costs. This is the judgment of the court, and it is entered accordingly.
As your lordship pleases.
Yes.
As your lordship pleases.
Or more. Let me take or more kudu. Or more kudu. Yes, Osifo.
My noble Lord.
Thank you.
I'm very grateful for for the judgment that we have just had. My Lord, we are constrained to ask that ordinarily we should be giving 250,000 naira cost for this judgment, sir. We are grateful, my noble Lord.
So that means you didn't hear me.
Sorry, my
I
Lord.
had in the judgment said parties are to bear their respective costs.
I heard it, my Lord. My noble Lord.
So what are you talking about?
As your lordship, please.
So the judgment copies could be ready even today.
As your lordship, please.
Thank you.
Yes, sir.
The third judgment. The third judgment is Dr. Akinlolu Abdulaziz Adelaja and University of Ilorin.
Yes, my lords.
Adelaja and Ilorin.
Yes, sir, my lord. My lord, we are here.
That's good.
My lord, sir.
Let me take your appearance.
With profound respect to my lord, L.O. Bello is my name. I most humbly announce my appearance. L.O. Bello is my name. L.O. Bello is my name, sir. L.O. Bello, sir. Yes, sir. Yes, my lord, sir. I most humbly announce my appearance for the claimant, sir.
Okay. Yes.
May it please my noble lord.
Yes.
May it please my noble lord. Taufik Olateju is my name. Taufik Olateju is my name.
You are for the.
I'm for all the defendants, my lord. I thank your lordship, sir.
Okay, thank you.
Thank you, my lord, sir.
The case is for judgment, and the judgment is ready.
Thank you, my lord, sir.
This is the judgment. In the National Industrial Court of Nigeria, in the Pressure Division, holding at Akure before His Lordship Honorable Justice K.D. Damla, dated this 28th of September 2021, suit number NICN/IL/09/2019, between Dr. Akinlolu Abdulaziz Adelaja and University of Ilorin, Vice Chancellor, University of Ilorin, Registrar, University of Ilorin, and the Bossa, University of Ilorin. Judgment. The claimant commenced this suit by a general form of complaint, which was filed on the 28th August 2019. The claimant claims against the defendants jointly and severally as follows. 1. A declaration that the letters dated 18 January 2012 and 21st March 2012, respectively written by the third defendant to the claimant, are capable of portraying and indeed portray the claimant as dubious and dishonest man, thus ought to be withdrawn. 2. A declaration that the withholding of the claimant's salary by the defendant since March 2019 till date is unlawful, illegal, and oppressive, ultra-vires, and constitutes unfair labor practices. 3. A declaration that the withholding of the claimant's earned academic allowance, EAA, by the defendants after payment of SEM to other academic staff is unlawful, illegal, oppressive, ultra-vires, and constitutes unfair labor practices. 4. A declaration that the claimant is entitled to be paid in full all his entitlements, pensions, and gratuity after the expiration of his letter of withdrawal of service resignation on 30th September 2018 as appropriate for any staff who has been in the service of the first defendant for more than 10 years. 5. A declaration that the claimant is entitled to be compensated for the humiliation, embarrassment, psychological trauma, and financial handicap he was subjected to as a result of the defendant's letter dated 12 January 2012 and 21st March 2012, and the defendant's unlawful withholding of his answers and allowances. 6. A mandatory order of this court directing the defendants, particularly the third defendant, to retract or withdraw their letters dated 12 January 2012 and 21st March 2012, respectively, for being disparaging to the claimant's personality and reputation. 7. A mandatory order of this court directing the defendant, particularly the fourth defendant, to immediately pay the claimant the sum of 1,916,817 naira 56 kobo, being his withheld salaries from 13th March 2019 till date, and his salaries henceforth until 30th September 2019, when his letter of withdrawal of service of resignation becomes effective. 8. A mandatory order of this court directing the defendants, particularly the fourth defendant, to immediately pay the claimant the sum of 909,055 naira 98 kobo, being his aggregate earned academic allowance EAA for 2 years after same has been paid to other staff of the first defendant. 9. A mandatory order of this court directing the defendants, particularly the fourth defendant, to pay the claimant the sum of 2,272,639 naira 95 kobo, being his aggregate earned academics allowance EAA for his remaining 5 years when SEM is released by the federal government and become payable to the staff of the first defendant. 10. The sum of 5 million naira only, being general damages jointly and severally against the defendants for the humiliation, embarrassment, psychological trauma, and financial handicap the claimant was subjected to as a result of the defendant's letters dated 12 January 2012 and 21st March 2012, and the defendant's unlawful withholding of his earned salaries and allowances. 11. An interest of 25% per annum on the total judgment sum as may be awarded by this court from date of judgment until sum is finally liquidated. The defendant, via a motion or notice, via a memorandum of conditional appearance on 20th March 2020 and a statement of defense alongside the list of documents to be relied upon, claimant filed a reply on 23rd March 2020. Facts of the case. The claimant was an employee of the first defendant. He was offered admission for MSc program in California State University and was on scholarship by the defendants from 2009. He later got a letter from the defendants in 2012 directing him to resume work after they believed he had completed his program. The claimant resumed without complaint. The first defendant asked the claimant to submit his certificate, to which claimant did not respond. The claimant enrolled for and completed a doctorate program in the first defendant while still a lecturer. Claimant resigned his employment in 2019 due to some stated dissatisfaction. He now filed this suit. Case of the claimant is as summarized above. The details, some of the details will be referred to in the main judgment, but it is summarized here. It's a very lengthy, long story, but that is the summary of the case. The case of the defendants is that the claimant was recalled to resume because he had finished the studies for which he was sponsored, and that they rightly asked him to submit the certificate for which they sponsored him, and then that also that that they rejected his first letter of resignation, because usually by the rules of the university, your resignation should take effect in September, which is the end of a session, and therefore that they did him no wrong. All other details will be found out in the body of the judgment. So the written address of claimant, defendant, final written address is whether from the facts and circumstances of this case, in consideration with the relevant laws, rules, and regulations, this case is not liable to be struck out. Whether from the gamut of evidence laid by parties, this case is not liable to be dismissed. Counsel submitted that the claimant did not prove his case, that EAA is not paid by the university but by the federal government, and that they are not responsible for it. And then he made other submissions. He submitted that the claimant failed to prove the fact that his earned allowance was released by federal government to defendants, and also gave authority to the defendants to pay him. This is also the argument of defense counsel on relief 4, that the claimant has not failed to has also failed to prove that he has fulfilled the condition for taking any steps towards getting his gratuity. On relief 5, counsel submitted that the claimant failed to demonstrate to this court how Exhibit AA7 and Exhibit AA28 affected him negatively. That is the letter recalling him and the letter asking him to submit his certificate, that he has failed to prove how it affected him negatively throughout his evidence, and his prayer for compensation for humiliation and embarrassment has not led credible evidence. Hence, the relief should be dismissed. In summary, those are the submissions of counsel. The defendant also filed a reply address in which he said that relief 1 and 6 of the claimant should not. Okay, there is one we are not seeing. That's claimant's final written address. His issues are whether the preliminary objection of the defendant is not devoid of merit. Then 2, considering the circumstances of this case, evidence adduced and exhibits tendered before this honorable court, whether the claimant is not entitled to the relief sought by him. On the preliminary objection, he argued that Exhibit AA29 was legally admitted and marked in evidence. He continued that the said document is a public document. It is also his argument that all the grounds of the objections raised by the defendant, that the argument that the claimant's case is unmaintainable, it is the contention of counsel that argument of defendant are spent and of no value, that reliefs of the claimants are maintainable and sustainable against the defendants. that it is on the issue of earned allowance that it is the submission of claimants that in respect of relief 3, the cases against defendants is against withholding the claimant and allowance by defendants after payment of same to other academic staff. Council also on issue of proper party, he responded that the non-joined of the Federal Government Academic Staff Union will still not strip off the jurisdictional garment of this court. On the argument that his case discloses no cause of action, counsel submitted that it is crystal clear from the facts contained in paragraph 42, 44, and 45 of the claimant's statement of facts that the cause of action has been disclosed. On issue 2, on relief 1 and 6, it is the submission of counsel that exhibit AAS 27 and AAA 28 portrayed the claimant a dubious and dishonest man, thereby constituting career stagnation. On relief 2 and 3, it is a submission of counsel that the withholding of the claimant's salary as well as his earned allowance by the defendant before they were paid when the matter is already in court is unlawful, oppressive, and constitutes unfair labor practice. He also added that the rejection of his notice of withdrawal of service is also unlawful. As such, the reason given by the defendant in this regard is an afterthought and thus not tenable. So the defendant also filed a reply. The arguments are set out their court's decision. Having read the pleadings and evidence of parties, the exhibit standard, and the final written address of counsel, this court is of the view that the long issue calling for determination is as follows: whether the claimant has proven his entitlement to any of the relief sought. In determining this issue, it shall be convenient to reproduce the prayers and determine the issues as raised and argue on them in the written addresses accordingly. Reliefs 1 and 6, the reliefs read as follows. A declaration that the letters dated 18 January 2012 and 21st March 2012 respectively written by the third defendant to the claimant are capable of portraying and indeed portray the claimant as dubious and dishonest man, thus ought to be withdrawn. 6. A mandatory order of this court directing the defendants, particularly the third defendants, to retract or withdraw their letters dated 12 January 2012 and 21st March 2012, respectively, for being disparaging to the claimant's personality and reputation. The complaint about these letters is that they are capable of portraying and indeed portray the claimant as dubious and dishonest man, thus ought to be withdrawn. These letters were tendered and admitted and admitted as exhibits AAA 27 and AA 28. These are 2012 letters. The letters respectively ask the claimant to resume work having completed his studies and also demand that he submits his certificate. The problem with this contention is that the documents tendered by the claimant himself do not tell a straightforward story. By paragraph 11 of his testimony, claimant testified as follows: that the duration and financial implication of the master program were well spelled out in the letter dated 15 December 2008 and other documents submitted to the defendant. A look at the claimant's letter dated 15 December 2008 and other documents submitted to the defendant leaves the reader with a lot of unresolved questions, and the claimant has offered no explanation. The questions and the claimant offered no submission or no explanation. 1. Exhibit SUP1, claimant's application for sponsorship, states that he wanted to read for MSc/PhD for a duration of 4 years. 2. Exhibit SUP3, also attached as Annexure IA to Exhibit SUP14. The claimant's certificate of eligibility states the level of education the student, that's claimant, is pursuing or will pursue in the United States as master's. The same document states that the student is expected to report to the school not later than 3rd December 2009 and complete studies not later than 1st December 2012. The normal length of studies is 36 months. By paragraph 14 of the claimant statement, he resumed in August 2009. Exhibit SUP5, letter of grant from first defendant, stated the duration of the program to be 3 years. Annexure 1B, attached to Exhibit SUP14, is the claimant's application for grant from the first defendant staff development fund. In that form, the claimant filled as follows. 6. Purpose for which grant is desired, MSc/PhD biology, stem cell biology. 8. Period of course, state date of commencement and completion, and it is stated as 12 January 2009 to 12 January 2011. Higher degree in view, MSc/PhD biology, stem cell biology. By paragraph 17 of the claim and witness statement, the claimant got sponsorship for his PhD in cancer stem cells commencing with 1st October 2011 and communicated same to the defendant. The questions created from the documents of the claimant for which no answer is offered are as follows. 1. Was the claimant to study for MSc alone or for both MSc and PhD? Was the duration of his studies 4 years, 2 years, or 2 years? Was the duration of his studies 4 years, 3 years, or 2 years? As at 18 January 2012, when Exhibit AA27 was written, was the claimant a master's student or a PhD student? More worrisome is the fact that the claimant responded to Exhibit AA27 asking him to resume work by simply resuming. He never wrote to explain that he was yet to complete his studies, whether MSc or PhD, for any reason whatsoever. When he was asked by Exhibit AA28 to submit his certificate, he never responded at all. Claimant is now offering his explanation in 2019 after resigning and suing the defendant. Without answers to these questions, it is not practicable to see how Exhibits AA27 and AA28 portray the claimant as a dubious and dishonest man. What is more, upon returning to work, the claimant remained in the employment of the defendant since then up to 2019, when he voluntarily resigned his appointment. During that period, he was admitted to read for his doctorate degree. Claimant was appointed the level advisor for the 200 students during the 2017-2018 session. What then has he suffered as a result of the two letters is left for imagination, which the court cannot do. The issue of career stagnation, argued by claimant's counsel, does not flow from the pleadings and evidence. It holds no water. The implication of all the above is that reliefs 1 and 6 fail and are hereby dismissed. Reliefs 2 and 7, the reliefs read as follows. A declaration that the withholding of the claimant's salary by the defendant since March 2019 till date is unlawful, illegal, and oppressive, ultra-vires, and considered unfair labor practice. 7. A mandatory order of this court directing the defendant, particularly the fourth defendant, to immediately pay the claimant the sum of 1,016,517 naira 56 kobo, being his withheld salaries from 13th March 2019 till date, and his salaries henceforth until 30th September 2019, when his letter of withdrawal of service resignation becomes effective. By the evidence before the court, parties are all agreed that the said salaries were paid in September 2019 during the pendency of this case. Any further argument on this issue is nothing but flogging a dead horse. The said withheld salaries having been paid, there is nothing for this court to order in respect of the said salaries. The issue has become spent. Reliefs 3, 8, 9. These reliefs are as follows. A declaration that the withholding of the claimants and academic allowance EAA by the defendants after payment of same to other academic staff is unlawful, illegal, oppressive, ultra-vires, and constitute unfair labor practice. A mandatory order of this court directing the defendants, particularly the fourth defendant, to immediately pay the claimant a sum of 909,055 naira 98 kobo, being his aggregate and academic allowance for 2 years after same has been paid to other staff of the defendant. Okay, it's reliefs 3 and 8 only. Reliefs 3 and 8 only, not reliefs 3, 8, and 9. From prayer 3 and 8, the claimant is saying he was committed in 2 years' payment. This is answered in paragraph 44 of the statement of facts. This is averred in paragraph 44 of the statement of facts. This fact was rather admitted by the defendants in paragraph 54 of the statement of defense. The only defense is that the claimant was asked to do clearance after the expiration of his 3 months notice, but the claimant failed, refused, and neglected to do so, hence the delay in the payment of his earned allowance. I have taken a look at the documents tendered and admitted in evidence. I find that exhibits OM8 and OM9 indeed confirm that the claimant did not do his clearance immediately upon expiration of his 3 months notice, but only did so on 9 September 2020. The failure to do the clearance caused a delay in the payment of his earned allowance, and the delay is therefore justified. I find that the claimant has established that other staff were paid 2 months EAA, that's earned academic allowance, for the claimant was omitted because he had not yet done his clearance, and so the payment of his EAA was delayed. Now that the cause of delay has been removed, the claimant is entitled to be paid the sum of 909,055 naira 98 kobo, being his aggregate and academic allowance for 2 years after them has been paid to other staff of the first defendant, and I so order the first defendant. Relief 4. These reliefs are as follows. A declaration that the claimant is entitled to pay in full all his entitlements, pensions, and gratuity after the expiration of his letter of withdrawal of service or resignation on 30th September 2018 as appropriate for any staff who has been in the service of the first defendant for more than 10 years. The pleading and evidence of the claimant in support of this relief is required. I have been in the service of the first defendant for more than 10 years. I am entitled to pension, gratuity, and other entitlements upon the expiration of notice of withdrawal of service, but I have a reasonable belief that the defendants will withhold my pension, gratuity, and other entitlements without cause. This prayer seeks for a declaratory relief. The argument is based on the fact that the claimant has served for more than 10 years. There is no evidence from the claimant that any staff of the defendant who has been in the service of the first defendant for more than 10 years is entitled to pensions and gratuity. There is no reliance upon the university's condition of service. I have taken a look at the university condition of service with OM3. Chapter 11 provides for retirement and terminal benefits. I find nothing in it to justify the claim that any staff of the defendant who has been in the service of the first defendant for more than 10 years is entitled to pensions and gratuity. It is the duty of the claimant to point this out to the court, but he failed to do so. The assertion may as well be correct, but it has not been proven to the court by the claimant, and consequently relief 4 fails and is hereby dismissed.
Let's go, please.
Relief 9. This relief reads as follows. Relief 9. A mandatory order of this court directing the defendants, particularly the fourth defendant, to pay the claimant the sum of 2,272,639 naira 95 kobo, being his aggregate and academics allowance for his remaining 5 years. Then I highlighted and underlined the remaining part, and it reads, when SEM is released by the federal government and become payable to the staff of the first defendant, underlining supplied for emphasis. The defendants contend that the issue of EAA is between the federal government and ASU. This has not been denied. Curiously, Relief 9 is asking that the claimant be paid when SEM is released by the federal government and become payable to the staff of the first defendant. This means clearly that it has to be released by the federal government first. There is no averment or evidence that it has been released by the federal government yet. There is neither averment nor evidence of the intention of the defendant not to pay SEM to the claimant when released, as the defendants have not done so with the ones already released. I agree with the defense counsel that relief 9 of the claimant is anticipatory and not anchored on any occurrence, but on speculative facts, and this court does not and cannot act on speculation. So long as the claimant's entitlement to the said 5 years EAA is not in issue, there is no cause of action as touching the balance of 5 years. Sorry, I have months here of 5 years EAA, which is to be paid only when released by the federal government and has not been shown to have been released yet. Relief 9 accordingly fails and is hereby dismissed. Relief 5, 10, and 11, I think that's the final one. 5, a declaration that the claimant is entitled to be compensated for the humiliation, embarrassment, psychological trauma, and financial handicap he was subjected to as a result of the defendant's letter dated 12 January 2012 and 21st March 2012, and the defendant's unlawful withholding of his earned salaries and allowance, the sum of 5 million naira only being general damages, jointly and several against the defendants for the humiliation, embarrassment, psychological trauma, and financial handicap the claimant was subjected to as a result of the defendant's letters dated 2012 and 21st March 2012, and the defendant's unlawful withholding of his earned salaries and allowances. 11, an interest of 25% per annum on the total judgment sum as may be awarded by this court from the date of judgment until SEM is finally liquidated. The humiliation, embarrassment, psychological trauma, and financial handicap he was subjected to as a result of the defendant's letter dated 12 January 2012 and 21st March, and the defendant's unlawful withholding of his earned salaries and allowances has not been proven. The court has already found that the delay in the payment of claimant's 2 months EAA is justified, The claimant is not entitled to any damages in the circumstance of this case. Release 5, 10, and 11 accordingly fell and are hereby dismissed. I make no order as to cause. Court order. For the avoidance of doubt, the court hereby hold and orders as follows. 1. The claimant's prayers all fell except for release 3 and 8, which succeed and are granted. The defendants are hereby ordered to pay to the claimant the sum of 909,055 naira 98 kobo, being his aggregate and academic allowance for 2 years. This sum is to be paid within 30 days of this judgment, failure upon which the sum shall attract 10% interest per annum. This is the judgment of the court and it is entered accordingly.
As court is, my lord. My lord.
Yes, hello.
Yes, sir, my lord. We are very grateful to my lord for the industry that went through the judgment, sir. We pray that may the Lord, may God Almighty Allah continue to strengthen your lordship in discharging the duty of your officer.
And you are welcome.
Thank you, my lord.
You are welcome. Tawfiq.
Yeah, thank you.
My Lord, on our part, we sincerely appreciate and thank your lordship for the industry exhibited in writing and delivering of this ruling. We pray to God in his infinite mercy to continue to be your guide and provide you with adequate wisdom as your lordship discharge the duty of your office. We also pray for more upliftment. In the name of Almighty God, we pray. Thank you, Lord, sir.
Thank you, my brother. You are welcome.
Yes. Yeah, my Lord,
This should be ready for collection even today.
As God please, my Lord, sir. We are grateful, sir.
I'm not asking you to come today. Come tomorrow.
Yes. Thank you, my Lord, sir. My Lord, we humbly pray your lordship to allow us to exit, sir.
You are welcome. You can exit.
Thank you, my Lord, sir.
Why is this thing like that? Okay, fail to dictate your microphone. But it's not covered the whole thing.
My Lord, sir, with the kind permission of the court, sir, with the kind permission of my Lord, sir, may I be allowed to exit the Zoom platform, sir?
Please do. You are allowed.
Thank you, Lordship, sir. Thank you, Lordship, sir.
You are welcome. I can look out. Okay. We have come to the end of the Zoom something, and I am also leaving.